All right, so what are the 7 steps a landlord should do when a lease is expiring? Today I'm going to be talking about what you as a landlord shall and at least should do when you have a tenant's lease that is reaching the end of its expiration. Now, while this presentation is primarily for California residential landlords, it also, I think, would be useful for California residential tenants to view in order so they can see what steps are probably coming as their lease is expiring and to help keep their landlord accountable and aware of what their responsibilities are. In other words, to help their landlord help them as a tenant. I am a California licensed attorney. My contact info is at the end of this presentation. This is general legal suggestions. These are not specifically tailored legal advice for your specific situation. For that, you obviously need your own competent attorney because every fact pattern is different. So, first, you will need to identify which leases will be nearing their expiration. And this is easy to identify since it will be on a rolling and recurring period, generally every 12 months. Now, even under California's tenant oriented AB 1482, which took effect in January of 2020, a tenant who fails to execute a written renewal of a valid lease entitles a landlord to terminate the tenancy under California Civil Code 1946.2. So, this is a protection for the landlord because it's difficult to evict a tenant after they have been there for at least 12 months. There is just cause that attaches. So, in addition to the rent caps of AB 1482, you also have just cause eviction, at fault or no fault just cause, which makes it hard, at least harder, to remove a tenant unless you have a legitimate basis, either something the tenant did at fault or something the tenant didn't do, but is otherwise permissible under no fault just cause because maybe the landlord wants to take the unit off the market, the landlord wants to move in himself or move in his family, etc. So this gives the landlord a pretty easy opportunity to end a lease and not necessarily require it to go to month, but end the lease and commence an unlawful detainer if the tenant refuses to a sign this lease renewal or sign it and return it on in a timely fashion. So this is why you have to have a deadline written clearly on the notice of expiration of fixed term lease and renewal offer. So this offer package should include everything you see on the screen. Hopefully my video bubble isn't blocking it. I'm just going to read it real quick for you because the last lines might be hard for you to see. So this package that you send to your tenant, regardless of whether they're going to renew or not renew, because you won't know until you give them this package, and this should be given 90 days prior to the lease expiration. And I have a suggestion at the end of the presentation on how you can easily keep track of these rolling 90-day periods as well as the 9 months after the start of the lease, so you remember to do this every time. But let me get right into the package. So the package should include things like the notification of the upcoming lease expiration, as well as an addendum with any new terms, which technically is optional, but if you're raising the rent, that should include what the new rent is going to be, obviously, and any other new terms that are going to take effect that haven't been in effect during the last lease term. Next, the tenant's option to renew the lease or terminate the lease with respective forms for each of the tenant's decision, A or B. And then the timeline for the tenant's decision, that should be very clear, usually on the front page. Also, a tenant's waiver of documentation. That benefits the landlord. I'll talk about that in a moment, as well as a security deposit disposition agreement. That benefits both the landlord and a tenant, and I will talk about that soon in this presentation. So, the lease renewal addendum should include things like what the current monthly rent is, what the new monthly rent will be when the new lease takes effect, any other terms, and then it also includes the dollar amount of the increase as well as the percentage increase. And why do you have to put the percentage increase? Because under AB 1482, you are normally limited to 5% plus change in CPI, never to exceed 10%, whichever is lower, and in some cases, in some localities, it's even lower than the statutory 5% plus CPI because they might have a more restrictive local ordinance that further caps the rent. So that's why you have to include what percentage the rental increase entails. So you are protected under AB 1482, and you're showing that you clearly did not exceed 5% plus CPI, let alone 10%, which you never can do no matter what if your property is subject to AB 1482. So you also want to check off any addenda that may have become recommended or required since the last lease term. And you also want to get the tenant to acknowledge that this leased unit is in satisfactory condition at the time of the renewal. That protects the landlord. If it is not in satisfactory condition, well, if you're a tenant, you should notify your landlord and refuse to sign this lease renewal until your defects that are not your fault or cannot be corrected by you, the tenant, have been addressed by the landlord and the landlord's maintenance personnel. So, also, if the tenant desires to renew, then you're pretty much done. Make sure you receive the lease renewal that is signed by the tenant. Make sure you've already signed it, and then keep the wedding signature copy for yourself, the original, and give the copy to the tenant. So make sure that you are abiding by any applicable rent increase caps when you're increasing the rent. And lastly, if you needed to provide any documentation, any new provisions, any new CCNRs that you're expected to follow because maybe the unit is in an HOA, etc., that's when you would apply, insert these addenda. Uh, it's different from a month to month, where you can just usually change the terms with 60 or even 30 days notice. But with a lease, you're a lot more restrictive, and that's part of the bargain, right? The lease benefits the landlord because the landlord can't just arbitrarily change the terms during the lease term. It benefits the tenant because the landlord can't just arbitrarily increase the rent during that lease term. So give the tenants a blank notice if, no matter what, you want to include this in the package. This is because you don't know whether the tenants are going to renew the lease or not renew the lease. So that's why you include all these forms together. So when the tenant does not desire to renew, then you want to allow the tenant to return to you, which you gave to them in a blank format, return to you this tenant's notice of non-renewal. And this is going to set several things in motion. This is why it's a good idea to do this all in one package and then let the tenant decide, basically choose their own adventure. Do they want to renew the lease? If so, that's easy. If they don't want to renew the lease, well, then that entails several additional steps, which the first of is let the landlord know that they do not want to renew the lease. And that automatically provides both landlord and tenant notification. It provides the tenant the notification that they have the right to request initial inspection, which is very important. And it also provides the landlord the forwarding address for the tenant right at that time. So you don't forget that important step of asking what is your forwarding address. Sometimes the tenant doesn't know it, so make sure you at least get their email address. Let me emphasize why this is important to request the initial inspection if you're a tenant. You want to request the initial inspection because you want to have several weeks, usually it's 2 weeks of notice prior to your move out date of what defects exist. So you can be informed of them and correct all of the defects, damage, dirt that you are allowed to repair from your level as a tenant so that they are not deducted from your security deposit, as they will be if they are not ameliorated by the time of your move out. So you have a few options as a tenant, but you have to choose one. If your landlord, make sure they choose one to protect yourself, to show that you did apprise them of their statutory right to request a initial inspection. So they can say, we decline the initial inspection, and then you're done. You have proof of it. Make sure you have some kind of proof of service. Next, we request the initial inspection and I want to be present, or we request the initial inspection and I do not wish to be present. So if the tenant desires to be present, they will click that box, check the box, either electronically if you've been set up like that, or they will do it manually back to you. They will give you their phone number, and then you will provide them with a 48-hour notice to enter the unit prior to doing this initial inspection, and you will mark everything on your move and move out report, which hopefully has 3 columns: one for the pre-move-in inspection, the second for the pre-move-out inspection, and the third for the final after the move out inspection has occurred. So that third and final inspection is conducted without the tenant. That's after the tenant has fully vacated. And oftentimes there'll be new damage that arose even after the initial inspection during the tenant's move out. It also could have arisen because the tenant's belongings were blocking the view of the damage. So generally, this pre move out inspection shall be performed 2 weeks or less prior to the move out if the tenant says yes to the initial inspection offer. If the tenant does not desire to remove, this will be, I'm sorry, if the tenant does not desire to renew, this will be step 5. You can request, although you're not required to force the tenant to do this, a waiver of the tenant's right to receive documentation with the itemized disposition of security deposit. What this means is the tenant can, but need not shall, waive their right to receive the associated documentation that accompanies any deductions in their security deposit, meaning they don't need to see the receipts and everything like that. They just need to see a breakdown of what was withheld from the security deposit if it was more than $150, and they need to receive back their balance, or a listing of what cannot be accurately calculated within the 21-day period, which I'll talk about in a moment. And they have to receive the existing amount of the security deposit back if there's anything left. Or let me phrase it a little more clearly. Basically, you have 21 days to return the security deposit to your tenant. You probably know that. Excuse me. If within 21 days you still haven't finished repairs, there's still work to be done, and this has happened a lot during COVID period. You couldn't find contractors. It was really hard to find supplies. So these 21-day periods were being elapsed, and normally that could subject you to potentially a bad faith trouble damages claim. But if you, the landlord, provide the tenant within that 21-day period an accounting of here's everything that has been done and deducted from security deposit, here's everything that has not yet been fixed, but we will give you the balance remaining as well as the receipts when I'm done. You can do that. Just give the receipts and the balance due within 14 days of that work being completed. So next, you want to request from the tenant the disposition agreement, security deposit disposition agreement. This will be step 6 if the tenant does not renew. And what this is saying is, do you want me to return your security deposit to you through direct deposit, or do you want me to send you the check through mail? And it's a good idea to get the email address of that tenant. That way you can have follow-up communication regardless of where that tenant ends up. Sometimes they stay in a hotel, sometimes they stay with friends while they re-establish themselves in a new apartment. So make sure that you have that previous agreement that I showed you that allows you to collect the tenant's forwarding address, and if you can at this time, get the email address on this form as well as the bank account information if that tenant so desires to have their remaining security deposit returned to them through direct deposit. Direct deposit is good for you because it expedites the return. It protects you from potentially going past the 21-day deadline if you're getting close. Whereas if you mail it, as long as you postmark it, you might be okay, but you're pushing it. So definitely don't wait until, the third week to do this. Step 7, if the tenant does not desire to renew, this is what I was talking about earlier. Within 21 days after the tenant has vacated, this is where you would include the itemized disposition of security deposit. It breaks down what deductions were made. It breaks down what your hourly rate is if you did the work yourself, and it shows exactly what amount was withheld for what reasons. So you're doing this as a landlord to protect yourself. You're making it very clear. And if you have pictures of the damage, even better, save that in case there is a small claim suit, which, if it's going to be litigated, it's usually, not always, but usually going to be litigated in small claims for security deposit disputes. They're usually well within the $10,000 threshold, unless you're a corporate tenant. Remember, if you are a corporation, LLC, you can only sue for half the jurisdictional amount, usually $5,000 in California as of 2023. There's also further restrictions if you have brought suit multiple times for certain threshold amounts, but that's for another presentation, the limitations on small claims. Next, the tip that I recommend for my clients, something that I use for myself, is when you have a tenant who's moving in, you're signing the lease, you should do two things: create a calendar invitation, calendar reminder, calendar event in your Google Calendar, your Apple Mail, your Outlook, whatever you prefer. Create a calendar event that is repeating. They might call it recurring event, repeating event. In other words, if your tenant moves in January, you start the lease in January, you know that that lease is going to expire in December, needs to be renewed. So you can add that recurring reminder every December. And better yet, you can add another event in September, which is 3 months prior to the expiration of that lease. So every September, for the length of that person's duration, they might stay there for 1 year, they might stay there for 15 years. Every September, you will be reminded, oh, I need to send Unit 12 the lease renewal paperwork every September. You can even automate it. I use a program called Door Loop to manage my clients' properties. It works fantastically well. It's just an unbelievable life changer for this type of management. And if this is something that you're interested in, my contact info is at the end of this presentation. I'd be happy to take an enormous burden of hassle, of stress, of liability off of your shoulders and manage your rental properties for you, either in San Diego or in the Northern California Bay Area. So use the calendar, use a program like Doorloop, keep things organized and accessible and automated. Fewer manual steps means fewer steps to overlook. In other words, fewer mistakes. So, in summary, if the tenant does not desire to renew, you want to receive the tenant's non renewal notice by the deadline, receive tenant's decision to request or decline the initial inspection. If the tenant says yes to the initial inspection, then you want to perform the pre-move out, aka initial inspection, within 2 weeks before the tenant's move out date. And then four, request from the tenant the waiver of security deposit documentation if you can, which is optional for the tenant. Also optional will be the security deposit disposition agreement. It's highly encouraged you communicate with your tenant now. After the tenant moves out, it's exceedingly more difficult, unnecessarily more difficult to communicate with your tenant and locate your tenant. And then lastly, within 21 days after the tenant has vacated, you should and shall provide an itemized disposition of the security deposit. And if you and the tenant have agreed to communicate through email, then that's okay. Otherwise, send it through the mail. Certified mail, not necessarily the better option. They can reject it, and then you could be in trouble because now you didn't send them their disposition and their remaining security deposit balance within 21 days. So, standard first class mail is probably fine. And then when the tenant desires to renew, it's much simpler. It's something that you can do year after year. You just need to receive the executed lease renewal addendum from the tenant. And if the tenant fails to return the executed addendum by the deadline you stated, then you can proceed to an unlawful detainer, which is what California calls an eviction. If you found this helpful, all I ask is that you give me a comment. Let me know what you like. Let me know what I can do better. Let me know what topics you'd like me to cover next. If you'd like to reach me, just hover your phone's camera on the screen over this QR code, and it should take you right to the contact me page on my website. I am happy to discuss what problems you are facing as a tenant or landlord. And as I say, there is a solution to every problem. However, there's also a problem to every solution. So you always need to think beyond what is the immediate next step. And for every action you take, there's going to be an action that can be used against you. So you need to tread carefully. You need to be intelligent about how you run your properties because you're almost never more than one decision away from losing some or all of your hard earned assets. Thank you for watching. I know your time is valuable. I don't take it for granted.